Dear friends, today we are taking a topic which is very important for every new entrepreneur or the Japanese industries who are coming to this country for doing any business. Business may be of many types. That may be a branch office, that may be a liaison office, that may be a project office. This I will cover into a different chapter, because once you invest, then which sort of a thing you should open in this country, what kind of business you are doing in this country, that is a different sector, investment sector, which I will cover into the different part. Today I am taking up only that subject, that once you start a factory or a commercial establishment or any business establishment in India, you require what things and precautions you have to take. In India, the labor laws are very rigid. It is not as simple as in other countries, as in Europe. One of the European employment laws lawyer consulted me in India and said, can you do provide the help from India doing the labor laws? I smiled, because their labor laws is only I can say very small number of labor laws. Our labor laws are very vast, very rigid. And why it is so rigid? Because India is very rich in human resources. So naturally the government wants to give protection, and they want to use the potential of the human resources. Therefore the labor laws are very rigid and complex. We should be very careful, and most of the foreign companies are coming to this country, even the new entrepreneurs, even the Japanese industrialists are coming to this country for cheap and economic labor. So we should be careful how we appoint them. So today there may be many topics in other chapters which I will cover, such as engagement, termination, dismissal, discharge, domestic inquiry, how to give a charge sheet, how to conduct an inquiry. Then the third chapter may be later on contract labor. Fourth chapter may be the general labor laws in India. There may be many topics, because labor law is very vast, as I told you just now. So today I will take up, and you can't take up all the things in one chapter only. So today briefly I will tell the people, the new entrepreneurs or the Japanese industries or the foreign companies which are coming to start a factory or a shop or commercial or a business establishment here, how you should, the first point comes, how you should engage a labor. Because if you engage a labor into a wrong head, it becomes very difficult to later on to discharge them. We must have heard the strikes, lockout, go slow. These are all what I say, the illness of the industries. So we should not try to get our industry sick or ill. How can we stop? If we take precautions, we will save. We will have all the precautions not to get sick, and also remain healthy, better productivity, and the things under control. So I take up today the topic engagement, termination, discharge, and dismissal. What is engagement? This covers appointments, how you engage employees. Engagement is also a very large topic itself. If I start speaking, I can speak hours and hours, and you will always find a new point in that. Hours, not wasting time, but it may be very large. So I will take the bullet points. Engagement is how do you engage? The labor laws in this country are the workman. Workman, I'm talking about the workman. There are two kinds of employees here in India. One, the workman. Workmen are those people who are covered by the Industrial Dispute Act 1947. The workman definition is not same everywhere. The workman definition, it is also very surprising. You say workman, it doesn't mean that it is same everywhere. The workman is different in ID Act. Workman is different in workman compensation. Workman definition is different in payment of wages, in Gratuity Act, in ESI Act, in PF Act. Everywhere the definition is different. So let us take the definition of a workman, what we are trying to, and that in context of engagement. How you should engage the employee. The standing orders, now I said the standing orders, since it is only ABCD of the labor laws, I must explain you what are the standing orders. As a new beginner and entrepreneur, you may not be knowing what is the standing orders. Standing orders are the backbone of any industry. It is the service conditions which tells how you will appoint, how will you discharge, how you will terminate their services, what is the procedure adopted. So many, all working conditions of an employee is given in a standing order, which is to be certified by the labor department. I will not focus standing orders. What I am trying to tell you, the engagement coming. So the standing orders, because standing order itself is a very vast subject, I will just cover standing orders, what is standing orders, and the workman, how you will engage the workman. There is a classification given in the standing orders. Standing orders are model standing orders if it is not certified by the state government or the labor authorities, and if it is, then standing orders, certified standing orders. This is having a classification. You cannot engage a person out of the scope of the standing orders. Standing orders are having classifications: temporary, permanent, casual, ad hoc, badli, substitute. These are the 3 standard 6 classifications where you can engage the workman. Employee may be officer also, employee is the workman also, but workman is not an officer because he is not covered by the ID Act 1947. So we are talking only about the workman. So you can engage them under these heads. There is one more point or a classification covering trainee. This is something a very complicated or a technical issue in a sense. Trainees are those which are appointed under Apprenticeship Act, which is act giving powers how to you will engage a trainee under Apprenticeship Act. But because the industry requires trainees, therefore what they are doing it, they appoint trainee under the classification of workmen under standing orders, and they take trainees also. So here I will cover trainees also. What the legalities of trainee, I may speak little later on. Let me come the first point. First, what is temporary? Temporary are those workmen. You are running an industry. You require for any project 3 months. You will appoint a trainee. You will appoint a temporary workman. You require some work is suddenly increased, you require for 15 days, again it is a temporary. For any temporary work which is not of a permanent nature, that is a temporary. So you appoint a workman under a temporary head. What is permanent? Permanent is it looks very easy, but it is not easy, because the dispute starts in any industry only this, because every workman wants to claim his permanency. What is permanent? Permanent is a job which is of a perennial nature, which is permanent in nature. So once you appoint the permanent, then you have to adopt for discharging. You have to adopt a total administrative procedure. What is administrative procedure? I will come later on. So then second I said, first said temporary, then permanent. Permanent is a workman who is appointed on a permanent or a perennial nature of a job, that is permanent. Permanent, you see the probationer. I forgot there may be one more classification, a probationer. What is probationer? Probationer is always appointed against the permanent vacancy. Am I able to explain you? It is not against temporary or any other classification. It is only against the permanent workman. Because once you want to, there is a permanent job, skilled workman, supervisor, or any permanent, or a clerk, there is a permanent job which your organization require. But you want to see how the workman is, how the person is. You want to see his performance. So you will appoint him under the probation. Probation is for a certain period. It cannot be throughout the life. Probation means maybe for 6 months, maybe for 1 year, maybe extendable for 1 more 6 months or 1 year more, but it should be for a reasonable period. What is a reasonable period? Next in chapter, I may provide you the judgments also. I am telling you all on my experiences, which cases I fought even in the Supreme Court. I and Mr. Arun Jaitley had appeared for Bank of India only for a permanency case. That this becomes a very important point. What is permanent? So I am coming here on a point of a permanent workman. Permanent is a 240 days a person covers in a year. 240 days becomes permanent. Most of the big companies employees, multinational employees, they want to claim themselves permanent because they get much more wages, they get much more benefits, much more facilities. I remember in Kanpur in an Indian Oil, even that time in 1980s, even a sweeper was getting those days 2,000 rupees, which is today a very huge amount. So they all wanted to claim to be an employee of the permanent workman of the Chanchap Urea was the name of the company. ICI was a British multinational, very rich multinational at Kanpur. There was a dispute, so only this that they want to declare permanent. Even the contract employees are also having the same problem, that they want to be declared permanent employees of the company because they are having much more wages, much more vardis, much more house rent, so many allowances. So the dispute starts about the permanency of the person. So permanent is that a person who is a permanent job in nature, perennial job in nature, and is appointed there. But to see his performance, I am trying to explain you in a better way by giving examples also. So that is first appointed under a probationer. This is the 8th classification, which I probably missed in the beginning. Probationer. What is probation? You see the conduct of a person during his probation. Suppose I keep Mr. A as cashier in my office. I will give him a probation for 6 months. I previously said I may give a 1 year, I may give a 2 year. I can't keep him a probation for 10 years. That well, I will observe his conduct in 10 years. This is not reasonable period. So there should be a reasonable period also. In one of the case I remember that was a case of BSF. There was a captain who was kept on a probation, and the service conditions were mentioning that time when I appeared in Supreme Court that every 1 month they will review this probation and they will keep. There was no length of period given, that how long will it continue. So I challenge the same thing in the Honorable Supreme Court, that you cannot do it for lifelong. You see the conduct. Purpose is you see the conduct of a probation. If it is satisfactory, then you regularize him for a permanent position. If it is not satisfactory, on the expiry of the probation, you can say that this is not satisfactory and you can discharge. This is discharge simpliciter. You can discharge from his services. That we are not satisfied from your services, therefore you are not confirmed. So you will do either of the things. Either you will confirm him on the completion of the probation period, whatever the probation you have given, or you can extend for 6 months or a year's time whatever is being provided in the letter appointment or in the standing order, because only two things are governed. Standing orders are only in the factories, not in the shop and commercial establishment by law. In shop and commercial establishment, you must be having letter appointment that is mentioning. If it is silent on that, then what you should do, the question arises that what probation I should consider. Then you should extend it for a reasonable time. You can keep him on a probation, because probation is only to check up your conduct. You see your performance. If you are 3 things I said just now, either you will say I am satisfied and you will regularize, or you will extend, or you will say that not satisfied, your services are not required. This is simple. There is no administrative action required for this kind of things. Once probation is confirmed, then he becomes permanent, and once he become permanent, then he won't, suppose tomorrow he does some kind of a misconduct, some mischief, then you have to do a adopt total administrative course of action. What is administrative course of action? That means giving a charge sheet, conducting an inquiry by a principles of following the principles of natural justice inquiry I will cover in a different chapter. I don't want to cover every time because everything comes in between, so I can't take up all those things. I will take in a different chapter. So you should conduct an administrative procedure, and administrative procedure, then inquiry officer will submit a report, and then the management will consider the report, and accordingly they will dismiss him and discharge him. So removing a permanent workman is a lengthy process. You can't do it simply, you get out. You can't do like this. So I was talking about probationer. I talked about after probation, completion of probation, the permanent workman, and then removal of permanent workman, you require administrative procedure. In brief, I covered how the administrative procedure goes on and what is the difficulty in removing a permanent workman. Therefore, one should be very careful in appointing a permanent workman. After permanent workman, we are talking about the classification of workman in brief. Then we covered temporary, we covered now permanent, and we also discussed about the probationers. Then after that, we come to a casual workman. We come to a casual workman. Casual are those employees, those workmen who are kept only for a casual jobs. What is casual jobs? Suppose you have some job for 2 days only. Suppose you have job for 3 hours only. Suppose you have job for 4 days only, for a very small period, which you don't know when it arises and when it finishes. There you keep a casual workman, a casual nature of a job. Then the question arises, these are the very complicated points. What is the difference between a temporary and a casual? Temporary, you know the period, that this is for 1 month, this is for 15 days. You know the period, you have judged it. But casual, you don't know it, suddenly you require it. Therefore, casual employment is also possible, and you keep the head under the casual nature of job, casual workers under classification of workmen. Then comes substitute or badli. What is a substitute or badli? Badli is a Hindi word, substitute is an English word. Substitute are that, suppose today Mr. A is a permanent workman, he is coming and is not coming. Then you keep certain categories, certain workman who knows that job as a substitute. So then that man will take up his job. They are the substitute workmen. This is a classification, because if any industry engages the workman or employee out of the classification, I am talking only regarding workman, out of the scope of the workman, out of the scope of the classification of standing orders, then that is not valid. So therefore you have to keep under those heads only. So therefore casual and substitute, you know the difference. What is the next point? I am just trying. Apprenticeship. Apprenticeship, we don't have to do anything, because Apprenticeship Act is there. They say the certain number of apprenticeship which they provide the name, you should employ in your industry. So Apprenticeship Act need not to be discussed here. I was talking at the beginning, I started trainees. Trainee is also very important, because I fought many points like trainees, but basically not in the Model Standing Order Act given anywhere. Trainee apprenticeship is given, trainee is not given, but most of the industries are keeping trainees, because suppose you require certain electronic, a person who is soldering, without knowing, training a job to your industry, he can't do that job. So you have to train him. Now under where you will keep it. So this was the question which we fought in the courts, which was represented to the, I remember the UP government times, it represented the UP government also, and trainee was somehow got it certified in standing orders by the state governments. So trainee, once satisfied, you can keep the trainees. That you are training for 3 months, for 6 months, for particular, like I give you an example also. This was a network, SCS, where Shivnada today is a chairman. I was a legal advisor for HCL, a network. We used to keep soldering people, and you have to train them for that. So the question arises, you can't keep a trainee, because the trainee is not being approved. So we convinced, and then trainee was certified. Still this question is a question debatable and going to the court whether our company can keep a trainee or not, because trainee is not in the model training orders. But somehow this practice is going on till now. Everybody is comfortable, so keep a trainee for some time, train him for a job, and then you can keep him. There is a difference in temporary or trainee. Temporary itself is a project is temporary. So now I covered in a classification of workmen today that if any new entrepreneur comes, he should be very careful that what kind of a workman he has to keep, because if he suddenly keeps a people without putting under right head, they will become permanent, and become permanent means once you complete 240 days in one continuous year. What is 240 days? Given in ID Act 1947. What is continuous year? Given in ID Act 1947. Continuous year is a separate, I can't keep on going, but I give an idea. Continuous means uninterrupted service. Again the law is, that's what the law becomes complicated, because the judgment keeps on coming. What is uninterrupted service? Means a person who is always on authorized leave. If a person is an unauthorized leave, unauthorized absent leave, this is called interruption. So that will not be counted. So if you are 240 days uninterrupted service, means you may be a medical leave, you may be a sick leave, all which is approved by the law and by the company. So if you complete 240 days in one continuous year, you become the claim of your claim for permanency becomes strong, or you have been kept from very beginning. Where the dispute is part, where you just keep a man and he's working for 2 years, 3 years, he wants to be declared to be employee of the company. He says I am permanent, and you don't want to give him permanent, because permanent dismissal will become very big problem. So therefore you want to say, and you don't want to give those facilities also. That problem comes in the contract labor also. So therefore you say you are not permanent. Then the question starts, how many years he worked. Then he says that 240 days in one continuous year. If this is substantially done, this doesn't mean that it gives a right to him to be claimed permanency, but it makes his claim stronger, because similarly temporary. So the labor law is very complicated. So once you start your industry, you should keep engage employee under right head, careful. I will also quote an example which I fought a case like temporary. I said in one of the project what happened, which was a Partapur had a feeder balancing dairy, where their fertilization and these kind of things used to take place. That project, the project was closed after 5 years. The employees were working more than 240 days in one continuous year. They continuously worked for 3-4 years. They claimed that we are permanent and we should be absorbed. Parag is making dry milk and dry milk powder and milk and ghee and all these things. So they were Meerut and Moradabad and so many industries they are having. They said we should be absorbed in other industries. This matter went to the court, and you know what was the judgment? You can't be made permanent, although you have worked for 240 days in one continuous year, but your claim for permanency doesn't stand strong. Why? Because the project itself is temporary. The project was given by some foreign country. It was a joint venture for 5 years. When the project itself is not existing, you can't claim permanency, and you can't be absorbed in the other companies of the feeder balancing, Partapur Parag industry. So what I am trying to say, even permanency in some of the matters, I fought some of the matters for MTNL also, some VSNL matters also, wherein I quote, the judge said himself, because there are certain, sometime you cover 240 days, but you have to see the circumstances also. What I said, I want to emphasize, then I will close this topic, that it is, your claim becomes stronger. It doesn't mean that it is a foolproof only. That's what I am saying. So today I covered that how a new entrepreneur or a Japanese entrepreneur, when he comes to industry, he should engage and appoint workers, because once you appoint under the wrong head, then it becomes a very big problem for discharging you, particularly permanent. If you don't do anything, they become permanent, and then for permanency, administrative procedure is a very lengthy procedure, and then it will go to the labor court, and then dispute, and then court to court. This will become a problem. So be careful about this. I think this chapter is sufficient. I may cover up the other point, the how to do administrative inquiry administrative action, what is this domestic and departmental inquiry, that itself can be stretched, because these are very, very important. If anything happens wrong, misconduct happens, you have to take a departmental inquiry. So I will cover this departmental inquiry or a domestic inquiry in our next chapter. Thank you very much.